Welcome to our Supreme Court Web Quest. This is by Joshua Hines and Jamari Burke. Do you know who the Supreme Court Justice is? If not, we're going to take a deeper look into his life as a judge. This is John Rutledge. He's the second Chief Justice of the United States Supreme Court. He was born in Charleston, South Carolina, September 17, 1739. His parents were John Rutledge Sr. and Sarah Boone Hext. John Rutledge Sr. was a Federalist who was elected President of South Carolina on March 26, 1776. He was also a well-known physician. His mother, Sarah Boone Hext, was also a Federalist born in Charleston, South Carolina on April 20th, 1792. John Rutledge received early classical education from his father, John Rutledge Sr. He then studied under Anglican priest John Andrews. He then studied under scholar David Rind. Eventually, he read law for 2 years under James Parson. Lastly, he studied law at Middle Temple in London. John Rutledge began his career as presidential elector under George Washington's presidential term. He then became an associate justice of the U.S. Supreme Court. Eventually, he became a Chief Justice of South Carolina Supreme Court. He was also a member of the Continental Congress, Stamp Act Congress, South Carolina House of Representatives, and many more professional stepping stones in his career. George Washington won the presidential election in 1789. Washington eventually nominated Rutledge as one of the inaugural Associate Justices of the Supreme Court of the United States. In 1794, a French ship commanded by William Talbot captured a Dutch cargo ship and claimed it as his own. Another man named Ballard was on the ship with him as well, and they were both Americans that renounced their citizenship to get away from American neutrality laws. Talbot claims that since he is a part of France now, he doesn't need to follow American laws. The Dutch owner, however, filed a lawsuit claiming that they have violated the agreement between America and the Netherlands. The case went to the Supreme Court. It was a unanimous decision that agreed that dual citizenship is possible and that they are still recognized as Americans, and that America's power extends to the sea as well. Some interesting facts about John Rutledge is that he was the first chief executive to be elected under the state constitution that changed the title of chief executive's office from president to governor. John Rutledge was also a founding trustee of the College of Charleston. John Rutledge's brother, Edward Rutledge, also served as governor of South Carolina. After Rutledge's many years of service, he attempted suicide by jumping off a wharf into Charleston Harbor. However, he did not die and was rescued by 2 slaves who witnessed him drowning. He then withdrew from the public and returned to Charleston until his death on June 21st, 1800, at age 60. Our court case is on Powell versus Alabama. Powell versus Alabama was argued on October 10th, 1932. It was then decided on November 7th, 1932. Alabama was the state in this case. Ozzie Powell, a black male, was one of the 9 black boys that was convicted in the Alabama court system. The state of Alabama thought the proceedings were fair in order to convict him. During the height of the Great Depression, on March 15, 1931, 9 African American males, 7 white males, and 2 white females rode a gondola train car. 7 of the African American males got into a fight with the other 7 white males, and it made the train stop in a nearby city. The black males were then removed from the train and were taken away to the police. So were the white females. The 2 white females were then questioned by the Alabama police, and then they said that the black males had raped them, and the police then took the black males to court. They then were tried by an all-white jury, and they were all convicted on the same day, given the death penalty. This was then taken to the Supreme Court, and it was in violation of the 14th Amendment Due Process Clause and the 6th Amendment as well. It was a 7-2 vote for Powell, and they explained that it was in violation of the 6th Amendment and the 14th Amendment Due Process Clause.